Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk a little bit about truck guns, and to do that we're going to have a look at the case of the Queen and Federuik. So when I talk about truck guns, what I mean is people frequently ask, hey, can I keep a firearm in my vehicle just as I drive around doing other tasks? This is especially people in rural areas. They might be saying, listen, I'm driving around, I'm fixing fences, and if I see some coyotes, is it okay for me to have a firearm on hand so that I can go and get that and deal with that? Pest, predator control, that kind of thing. So let's have a look at this case and talk about what it says, what it doesn't say, what the problems are, and go from there. All right, so this is a Saskatchewan case. It's a provincial court case in Saskatchewan. It's been cited a couple of times, but not heavily cited, but it's one that sometimes people bring up. So Her Majesty the Queen and Lori Mildred Federuik. I might be pronouncing that wrong. I really wish they'd started including pronunciation guides in case names. So if I ever become a judge, that's something I'm going to include. Here's how you pronounce the names of the parties. All right, introduction. The defendant was charged for, on November 17th, 2005, storing a firearm in a careless manner, and for resisting a peace officer engaged in the lawful execution of his duties, both charges arising out of events that occurred in Nipawin, Saskatchewan. And there was an earlier decision on charter issues. We're not going to cover that, but moving on. There's also two issues on this one, and I'm only going to be covering one of them. Issue number one is the careless storage of the firearm. So one issue to be decided is whether the firearm was stored or whether it was transported, and if the former, whether that storage was done in a careless manner. The other issue, and this is one I'm not going to cover, revolves around whether or not the conduct of the defendant amounted to a resistance. Basically, she was quite intoxicated. She was being a massive nuisance for the police. And so the question was basically, if she's just super drunk and thereby, causing the police a lot of difficulty because she's combative, because she's, uncooperative, is that enough to amount to resisting a peace officer? Short answer, yes. Moving on. Let's look at the careless storage aspect. Constable Waldbauer and Constable Egan, both members of the Royal Canadian Mounted Police stationed in Nipawin, Saskatchewan, responded to a complaint made by the adult daughter of the defendant. The daughter complained to Constable Egan that her mother had come to the daughter's home, was very argumentative, and would not leave when asked. The officer was advised by the daughter that the defendant was flipping out and that the defendant had stated that she was going to blow her head off. By the time the police arrived at 9:40 p.m., the defendant had left. The officers went right away to the defendant's house, a few doors away, and encountered her on the porch area there. So if you're wondering, how does this start? Well, it starts because the defendant is being a bit of a jerk ass. That's, I guess, the way to put it. Being a major nuisance. Each officer testified that he or she heard growling noises coming from the bushes near the daughter's home. Constable Wildbauer testified that the noise was like a bear or a dog sound, although a sound clearly made by a human. Constable Egan referred to the noise as a growling sound coming from the bushes just south of the daughter's residence. Both officers testified as to following that noise towards the defendant's house. Although Constable Waldbauer could not say that it was the defendant who made the noise, he thought it was her because no one else was in the area. Constable Egan testified that she caught a glimpse of the defendant going from her porch into her house, presumably at the time the police were following the noise. The defendant testified that she was not growling and that her daughter's dog was tied up in the bush. Rather, she said, she was in the porch area when she saw the police coming and came out to speak with them. Now, these are different versions of events, but this whole growling noise thing is a bit weird. So let's see what the judge has to say about that, because that's a strange fact, right? That's a strange bit of detail. I have some difficulty in reconciling the two versions of events, and I find the defendant's explanation of her daughter's dog being in the bush somewhat suspicious. My finding is that the defendant, who was by her daughter's account, as communicated to Constable Waldbauer, flipping out, was very upset and undoubtedly would be breathing hard when she left her daughter's home to go to her home. I conclude that the growling that each officer heard was heavy breathing. Now that seems weird to me. I've never really mistaken heavy breathing for a growling noise, but judge heard the evidence, so the judge is in the better position to know this, but it just seems strange to me. I accept Constable Egan's evidence that she saw the defendant leaving the porch area and going to the house, as opposed to the defendant's version that she saw the police coming and thus came out of the porch area. The evidence satisfies me that the police were not far behind the defendant, who was clearly very upset. My finding as to this state of upset that the defendant was supported by the observations of the officers at the time that they met with the defendant. I mean, I might say, listen, I don't know what the growling is. I'm not going to put any weight on growling because I don't know what it is. But it seems strange to say, oh, well, that must have been heavy breathing. Nothing turns on this. This doesn't matter, this whole growling issue, but it's just kind of weird. And it kind of puts into some perspective the judges kind of what they're looking at here, what this case is that they're playing with in terms of how they come to legal rules. So each officer testified that the defendant was drunk and argumentative. Constable Wildbauer testified that the defendant had a strong odor of alcohol on her breath, was basically incoherent, and was swaying back and forth. And she was arrested based on, all of the allegations. Constable Egan testified that the defendant was grossly intoxicated, and she echoed the concerns that Constable Wildbauer had respecting the defendant's balance. Constable Egan testified that she had real concerns the defendant would fall over. As she put it, when she spoke, she wasn't making any sense, and Constable Egan also noted that the defendant was very verbally belligerent. I'm cutting out a lot of details here about just how much she's fighting back, because that's really related to the resisting the peace officer thing, and not so much the storage aspect. But it is kind of important here to consider the fact that she is apparently really, really drunk. When often lawyers will ask people to put somebody's intoxication from a scale of, 0 of cold sober to 10 of nearly dying of intoxication. I mean, I'm not sure where exactly she is, but this sounds something like a 7, 8, somewhere around there. I'm just kind of guessing because, again, I haven't heard the evidence, but there's a lot of intoxication details here. As to the firearms charge, the evidence of Constable Wildbauer is that he heard Constable Egan talking to the defendant while the police were at the house, and that the defendant stated that there was a gun in the car, inviting Constable Egan to take a look if she wanted to. So you know how I frequently talk about don't talk to the police? Well, this is the kind of thing you want to not talk to the police about. Hey, the police are there. They think you've been in an argument with your neighbors, or with your family members, and, that you've been talking about using a firearm and you're drunk off your butt. Why don't you just tell the cops that you have a gun and also tell them that they can search for it? Or maybe the other thing, you should maybe talk to a lawyer before you decide to speak to the police, because I don't think this statement helped her at all. Constable Egan, having known of the threat by the defendant to shoot herself, had walked over to the car while at the house to see if there was a gun inside, but could not see inside the vehicle. Now, I should note as well, it's possible that these officers could have gotten a warrant to go and search the house or search the vehicle or both for a firearm, but it's also possible that they wouldn't have been able to. There's provisions that might have allowed them to search for public safety reasons, but it's not clear that they had enough evidence to actually go and start that search. So her volunteering this information was harmful. That was when the defendant volunteered to her that there was a gun inside the vehicle and that the constable could take a look if she wished to. At this point, the struggle between the defendant and Constable Wildbauer ensued, which ended with the defendant being placed in the police car. After the situation was stabilized, Constable Egan went back to the car and located the rifle in the back seat under some clothes with the bolt of the rifle in the open position. A magazine that ultimately turned out to contain ammunition for that rifle was located in the console of the vehicle. Constable Wildbauer test-fired the rifle a few months later using the magazine located in the console of the vehicle, and there is no dispute that the rifle was operable and that the magazine of ammunition was able to be used in that rifle. Now, I should note, in my area at least, they don't let officers test firearms themselves anymore because, quite frankly, that is a potentially dangerous thing to do. If you don't know what state some of these firearms are in, sometimes firearms are found that are homemade. It makes more sense to, put it into some sort of rig and test fire it with a string so that you're not holding some gun that you don't know where it's been and what it's been doing, up to, holding it up to your face and in your hands. Most officers are not really trained to do any of the steps required to determine, for instance, if the bore is obstructed. And so just having them test fire a gun actually creates some risk. So in my area, they don't do the test firing themselves. They send it off for testing. All right. The undisputed evidence of the defendant was that she had been hunting between approximately 3 p.m. and 5:30 p.m. that day, and upon her return to her residence had parked her vehicle in the driveway. Her vehicle, a 1990 Dodge Shadow, was a hatchback. That is, it had no trunk. She locked the rifle in the back of her car, wrapped up the rifle so that no one would see it, and put the magazine in the console. The gun was not loaded. So, position of the parties. Count 1 was amended at trial and charges the defendant as follows. Did, without lawful excuse, store a firearm, to wit, 303 British bolt-action rifle in a careless manner, contrary to Section 86 sub 1 of the Criminal Code. So, this sounds to me like it might have been a Lee Enfield, but I don't know. The defense argues that the defendant, having been hunting earlier in the day, was entitled to leave her firearm in the vehicle for a reasonable period prior to returning it to the storage cabinet in the house. Additionally, the defense argues that the way the gun was lodged in the vehicle was in compliance with regulations that deal with the storage and transportation of firearms, and further questions whether or not the firearm was stored, as charged, or transported, as also referred to in Section 86. So this is an issue that comes up sometimes. Is this gun being stored or is it being transported? Because those two things have very different rules in terms of how they need to be, what the regulations are. The Crown argues that this is not a case of transportation of a firearm in a vehicle, as the defendant had ample time to put the firearm back into safe and secure storage. As well, the Crown argues that the manner in which the firearm was left in the vehicle was such as to be careless based on the facts, and that therefore the charge is made out. And we're going to skip over the other charge, which is, again, the resisting the peace officer. Storage of a firearm in a careless manner. There is no doubt that the rifle is a firearm, as defined in the Criminal Code, and that there's equally no doubt that the rifle was operable. What needs to be determined is what the applicable standard of care is, and whether or not the defendant has fallen below that standard. So, sometimes there's an issue, is this gun actually a gun, or is it just sort of a gun-shaped object? Does it work? Could it be made to work? That wasn't an issue here because they could fire it. In the Queen and Blanchard, the justice undertakes a useful review of the fault requirement in cases broadly described as dealing with penal negligence. Without repeating the analysis set out in that case, or other cases for that matter, I'm satisfied that the appropriate method of analysis is to determine whether or not the defendant's conduct reflects a marked departure from the standard of care of a reasonably prudent person in order to assess on an objective basis whether or not liability has been established. And this seems to be a correct statement of the test. Marked departure of the standard of care of a reasonably prudent person. So carrying on from that, each counsel takes the view that I can refer to the regulations, in this case the storage, display, transportation, and handling of firearms by individual regulations, as a framework to assist in determining an appropriate standard for storing or transporting firearms. That was the approach taken in Blanchard, and is an approach I will incorporate in deciding this case. Now, I think that's correct. There's nothing wrong with them doing that. The regulations are prima facie, which means sort of as a starting point before we know anything else, the standard of care. So the regulations as a starting point, if you're breaking the regulations, you may be careless. But you have to go beyond that because it has to be a marked departure. So, and there are some situations where you can be breaking the regulations and not careless, or where you might be careless even though you're following the regulations. Those are two separate charges, and they have different tests that apply to them. So dealing firstly with whether or not the rifle was being stored or transported, I find that the firearm was stored, albeit temporarily. The defendant's evidence is that she was hunting earlier that day and returned at approximately 5:30 p.m. The complaint to the police, made by the defendant's daughter, was received at 9:22 p.m., almost 4 hours later. There was ample time in the interim for the defendant to take the firearm from the car and return it to secure storage in the house. The fact that she elected to wrap the rifle in clothes to make it less visible to passers-by supports my view that she deliberately elected not to return the firearm to the house, opting instead to store the rifle in her vehicle. So this raises some questions, like what happens if you've been hunting for 3 days and you're just completely bagged out, and so you just arrive home and you do nothing with the gun. You do absolutely nothing other than just stagger in and fall asleep for a little bit to get some energy to unpack the car. This might be a different situation because she actually took steps at that point to wrap the rifle in clothes, which then has the the judge saying, well, why didn't you just bring the gun inside if you're, doing all of this? So in The Queen and Carlos, which is a video I have covered, I'm going to try to remember to link it here. The Supreme Court allowed a Crown appeal and entered convictions on 1 count of careless storage of a firearm under Section 86(1) and 2 counts of contravention of the regulations. In that case, the defendant had testified that he had taken 3 guns out of his safe to clean them, had loaded them, and was then interrupted by the arrival of the police, who were at his home to execute a search warrant. He hid the guns and was acquitted at trial, an acquittal that was upheld on appeal on the basis that he had not stored the guns. In allowing a further Crown appeal and entering convictions, the Supreme Court noted that there is no requirement that the accused plan a long-term or permanent storage. As as Ryan J.A. noted in the dissenting Court of Appeal judgment, so that's a justice in Carlos. So this is the losing position at the Court of Appeal, which was then the winning position at the Supreme Court. A firearm has been stored when it has been put aside and the accused is not making any immediate or present use of it. There is no need to establish that the firearm has been put aside for a lengthy period. Such a requirement is ambiguous and does not provide any guidance as to when use has ended and storage has begun. So you can see also that Carlos is a case where they lost, or the Crown lost at trial, they lost on appeal, and then they won at the Supreme Court. This happens. You don't necessarily know how some of these legal issues are going to shake out until they reach, the big leagues, the top, the end of the line. Supreme Court has the last word on this. Carlos basically means that any short-term storage, if you're storing it even for 15 minutes, that can count as storage. So was that storage careless? The regulations respecting storage of a non-restricted firearm, which this rifle is, state 5.1, an individual may store a non-restricted firearm only if A, it is unloaded, B, it is rendered inoperable by means of a secure locking device, rendered inoperable by the removal of the bolt or bolt carrier, or stored in a container, receptacle, or room that is kept securely locked and that is constructed so that it cannot readily be broken open or into. And it is not readily accessible to ammunition unless the ammunition is stored together with or separately from the firearm in a container or receptacle that is kept securely locked and that is constructed so that it cannot readily be broken open or into. All right, so there's a whole lot there, right? And then they go over some bits on transportation, but they've already found that this wasn't being transported, so we don't really care that much. Short definition. It would have been fine so long as it's unloaded if it's being transported, but the judge has already found not being transported. On the evidence, the defendant was not in compliance with the regulations as to storage. There is no evidence that there was any type of locking device on the rifle, and the evidence from each of Constable Egan and the defendant is that the bolt was not removed from the rifle. A vehicle is not any of a container, receptacle, or room, and in any event, the vehicle was not securely locked and constructed so that it could not be readily broken into. One could simply break the window of the vehicle to gain entry. The ammunition was readily available in the console. Now, here I want to stop and go, how isn't a vehicle any of a container, receptacle, or room? You can contain things in a vehicle. In fact, people often use vehicles for transportation or storage of things, things that you also use containers for. Many vehicles boast of their, how much stuff you can fit in them. They'll say, hey, this is what the cargo capacity is of this vehicle. And, both in terms of weight, how much can the vehicle physically move around, but also in terms of volume. If you've got a cube van, well, that's got a lot of storage capacity to it. You might say, okay, well, yeah, but it drives around. But let's imagine that your vehicle doesn't. Let's imagine that you have got this old classic vehicle, but it's never going to drive again. It's got too much rust in too many critical places. You're not going to be able to get this thing fixed. But you have the idea of, hey, you know what? I could use this thing as kind of a shed. I could make it look nice, but I could also, add more locks to it. I could reinforce it. And then it would be a great storage location. Or maybe you're just planning on storing stuff in it that, you're not worried if it gets stolen. You're storing your old clothes. Nobody wants to take those, so why not? I don't see anything fundamentally other than having an engine to it that makes a vehicle not a container or a receptacle. And, if I take an old steamer trunk and I slap some wheels on it and a small engine, does it stop being a container? I don't know that this is the correct analysis. I don't know that this is something that necessarily should be followed by future courts, but it is something that you may need to consider if you are a gun owner. The fact that we have this case that says that a vehicle does not count as a container. So when people ask me, oh, well, isn't the vehicle itself a locked container? I go, don't rely on that, because there is at least one case that could cause you serious problems. I would love to argue this issue, but don't do anything that makes me have to argue this issue, because as much as I would love to get into this fight, it is one of those interesting legal questions, which means expensive. And, as a lawyer, I come at these interesting legal questions from, I'm making some dollars on this and I can play around with the intellectual puzzle, but you're the one paying for it and you're the one at risk of jail and consequences. This is really a crap deal for you. So it's worth following the sort of safest legally stance, which is assume that the vehicle doesn't count as container, this ends up being weird. It means that we end up in this weird situation where, legally speaking, it's equivalent if she'd stored the firearm in the vehicle or if she'd stored the firearm next to the vehicle. Those seem like two very different scenarios to me. Anyway, I could rant on this for a while, and maybe I will rant more on it later. But they also note the ammunition was readily available in the console. They also talk about how you could simply break the window of the vehicle to gain entry. Well, that applies to so many containers. Most containers that people use to store firearms are plastic, and they take some breaking into to get into, but not that much. There's only so far you can go in terms of making these things, hard to break into before it becomes impractical to actually move these things around and transport them. So, The other thing I'll just note here is that this whole analysis may be changed dramatically if this vehicle has a proper locking trunk, because the trunk doesn't typically have a window in it, and the trunk may be more difficult to break into. Not impossible, certainly, but more difficult. The defendant relies on that portion of the regulations that deal with transportation of a non-restricted firearm, but for the reasons given, I have concluded that the firearm was stored, with the result that Section 10 of the regulations is not applicable, which is why I didn't read them out again. To the extent that Section 10 can be relied on to objectively assess the standard of care exhibited by the defendant, I note that the vehicle could not, in any event, be securely locked. So, it's again very difficult to see how it couldn't be securely locked as contemplated by Section 10, which I guess I'll have to look at here. So Section 10 is noted about the individual may transport a non-restricted firearm in an unattended vehicle. So this is sort of a provision that contemplates that on some transports you may need to stop the vehicle. Let's say you're driving to the range and halfway there you look at the gas knob and you're at empty. You got to pull in and you got to get some gas. And maybe you buy a gas station burrito, and by the time you get to the next gas station you really need to use the bathroom. And you're going to be in the bathroom, unable to see your vehicle for, a little bit of time because that burrito's really done a number on you. So the vehicle is going to be unattended. Here are some rules for that. They say, when the vehicle is equipped with a trunk or similar compartment that can be securely locked, the non-restricted firearm is in that trunk or compartment and the trunk or compartment is securely locked. And when the vehicle is not equipped with a trunk or similar compartment that can be securely locked, the non-restricted firearm is not visible from the outside of the vehicle, or the part that contains the non-restricted firearm is securely locked. The reason why I'm coming back to this is because this, I think, shows a problem with the judge's analysis here, because this clearly contemplates that the vehicle itself could be securely locked, whereas the judge here is saying that the vehicle could not in any event be securely locked. And there doesn't appear to be anything in the evidence to say that this is a defective vehicle where the locks aren't working. If your locks aren't working, then it can't be securely locked. But what the judge points to is you could simply break the window of the vehicle. Clearly, Parliament, when they were designing this, had to be aware that cars have windows. I don't think there were any vehicles on the market at the time of Parliament designing this law that didn't have a windshield and a rear window and, side windows so that you could see the mirrors. So it's very difficult to reconcile this interpretation of the law with Parliament's intent. I think that this is a flaw with the judge's reasoning, and it's a flaw that doesn't... The problem here is that this is a flaw that doesn't actually go to the judge's ultimate conclusion. It's this is an aside. It's what we call obiter, but it kind of shows that the judge might be applying the wrong standards generally to what counts as securely locked. And so I would have appealed this decision. I would have appealed this because, and there's all sorts of reasons why people don't appeal. Either they don't think that the issue is an issue, maybe somebody disagrees, and there's lots of legitimate disagreements in the law. But often it's a question of, the client doesn't have the money for the appeal because appeals are expensive. Even an appeal that you're doing for free from the perspective of a break-even appeal, you still might ask the client, hey, can you cover transcripts for this? And those are expensive. So, and sometimes clients, even if you say, hey, listen, I'm willing to take a loss on this. I just think this is a bad decision. And, not a lot of lawyers are willing to do a file at a loss, but, this is a hypothetical. If you say this is such a bad decision, I'm so annoyed by it, I'm willing to cover the cost of transcripts, filing fees, all of that stuff, all of my time. Sometimes clients are just like, you know what? At the end of it, I'm just relieved that it's done. I don't want it to be still going. I don't want it appealed. And the client gets to make the decisions, which it's kind of weird when we have these precedents that sometimes, we're relying heavily on these precedents that have never actually been challenged, and they just kind of become unchallengeable, notwithstanding the fact that they might have been flipped at the time on an appeal. This is something I've always found to be weird in the law, but it is what it is. Anyway, as I say, this analysis on securely locked suggests to me that they're applying a overly strict standard of securely locked here. And that might be a problem, because if it's overly strict on this term, maybe it's overly strict on the whole container, the vehicle as a container itself. So unless I'm satisfied that the conduct of the defendant exhibited a marked departure of the standard of a reasonably prudent person in the circumstances of the defendant, I must acquit her. In this case, the defendant knew that she had an operable firearm and ammunition for that firearm in a locked hatchback car. Whereas she did take some steps to conceal the firearm, a reasonable person, in assessing the potential risk of the vehicle being broken into and the serious consequences that could arise if the firearm and ammunition were stolen, would have adverted to that risk and returned the firearm to a safe location. Instead of doing that, the defendant started drinking almost immediately after returning from her hunting trip. On these facts, I am satisfied beyond a reasonable doubt that the conduct of the defendant displayed a marked departure from that of a reasonably prudent person, and I find her guilty of count 1. Now, I've already mentioned just how sauced she was, just how much of a nuisance she was. But the thing I wonder about here is the defendant started drinking almost immediately. What does it matter what she's doing? What? I get that this is something where we might be extra annoyed if she's drinking, but what if she's not drinking? What if she's going and taking a nap because she's really tired because she's been out, that much time? Does that make this storage itself any different? What if she goes and watches TV? What if she makes dinner? What if she, why does the drinking matter here? And I don't really see it. So there are, this would have been a much easier case had they just charged the, contrary to regulations, but they didn't do that. And there's a whole lot of places where the facts on this could have been a little different. Let's imagine instead of a hatchback car that we have a vehicle with a trunk. Or let's imagine that we've got a vehicle and there's a container in the vehicle. Now, the vehicle itself might actually be more durable than the container. Lots of containers that are, considered perfectly adequate for this kind of storage might actually be less difficult to break into than a vehicle. But yeah, this is a bit of a weird case. So the practical implication of this case existing is that I wouldn't go so far as to say that this case means that you can't have a truck gun or the like. And certainly if you're driving around, you're driving around fixing a fence or inspecting fencing, or doing whatever, then that firearm is probably under the more generous standards of transport. But if you're keeping it there when you go home to go to sleep, then you're probably now into storage. You have chosen to leave that firearm in the vehicle. And so sometimes people say, no, listen, anytime your firearm is in a vehicle, it's in transport. This case, and I think that this part of this case would be upheld, says that, if you decide to leave it there overnight or the like, that it might be now in storage. Now, when I say if you decide to leave it there overnight, there's different possible scenarios for this, and some of them get fuzzier. Because this is at her house, right? This is the place she lives. But let's say you're talking about overnight at a hotel. And a hotel is a bit of a different scenario. And there's various reasons why it might make more sense to leave your firearm in your vehicle at a hotel than to bring it inside. For one thing, you're not the only person with keys to your hotel room. And so if you're bringing it into a hotel room, you probably don't have a safe within the hotel. And, the cleaning staff might be able to go in and go, hey, free shotgun. The cleaning staff probably doesn't have a key to your truck or your car. So that's a consideration. Hotel rooms are also distressingly easy to break into in most cases. They're required to be so because of firearm regulations. And I'm going to give a shout out here to Deviant Ollam, friend of mine. Go check out his channel because he's got lots of stuff about, how insecure some of these things are. I'll try to link. I think I'm only allowed one sort of pop-up card here, but I'll put on the end thing a link to one of his videos about some of the insecurity issues around hotel room doors. I would be more confident, and locks in general have all sorts of problems. I'll do some videos at some point on, how flawed locks are and how some of the difficulties there. But a hotel room, in my estimation, might be, and I say might, be more vulnerable than your vehicle. It might not seem unreasonable to leave it in the vehicle in that circumstance. And in that case, it might count still as transport versus storage, but these are really muddy and uncertain circumstances. But this notion, that it's always in transport in a vehicle, it just can't be supported. There's lots of scenarios where it's obviously not the case. Let's imagine that you've got a truck. It's been sitting on your property. You haven't moved it in 3 years. You don't even know if it still runs, but you've got a firearm in there. Is it in transport? I can't see a judge finding that. In terms of, what is required there, you're going to be much better off if you are following, or if you have more locking devices and more security. So if we imagine sort of an ideal situation, a trunk that is itself locked, has no windows, with a locked container inside that trunk with the firearm and, ammunition, or possibly even a separate locked container for the ammunition, you're getting into better storage at that point. But carelessness is kind of a fuzzy scenario, and there's all sorts of ways that a judge could say, listen, I think this is careless, even though you took all of these steps. So ultimately, this person is guilty on that count, and that's kind of the end of the day here. Sometimes people have said, listen, this case means that you simply can't do a truck gun or a trunk gun or, any of these things. I wouldn't go that far, but I would say that there are some legal hazards to doing so and that you should be very careful. Certainly, I have seen somebody suggest online, and I'm not calling them out here, I'm not posting any screenshots, but they suggested that it would be perfectly fine to just leave an unloaded firearm in the, gun mount, a window gun mount of a truck, and just leave it there. I would not want to run that case in court. I think that would be a very bad day. So, yeah. Anyway, thank you for watching. I hope this has brought I was going to say a little bit of clarity, but I kind of feel by the end of most of these cases that I may not have brought clarity so much as just more questions. But hopefully you know a little bit more about the issues involved in this kind of thing. So thank you for watching. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Mike Kyle Martin, Jean-Guy Toussaint, CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babin Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you once again for watching. I also want to thank all of the $10 Patreons who will be in the crawl immediately following, and all of you for watching. I really do appreciate, it's kind of weird to have people who watch. It's not something I expected out of my life, but I do appreciate that, you guys are supporting. And there's also, as I mentioned in some previous videos, the locals option. If you want to watch this, if you're a supporter, you can watch videos like this ad-free there. Thank you once again. I hope this has armed you with knowledge, and until next time.